For anyone who's signed on already too, I am taking attendance, so I've gone through and marked you off. I sent a message to Joel Bierbauer because I don't have your attorney number though. So you may want
Okay,
to check your chat.
he's my law clerk, so he's not
Oh,
yet an
that must be
attorney.
why. Okay. He
All
was the only one I didn't know the name of. Okay.
right. Welcome, everybody. This is continuing legal education titled Old Judgements, Renewals, and Pro Supps. It's brought to you by the St. Joseph County Bar Association, part of your value added for being a member of the Bar Association. Today, we're going to look at Indiana Court of Appeals case Lewis v. Rex Metal Craft, Inc., 2005 case. With me are Ian Flora, Ian Septoski. My name is Mark Telloyan. I've asked both Ians to go ahead and give us a 30-second introduction, self-introduction, so it's not like just strangers talking here. So Ian Flora, why don't you introduce yourself, where you grew up, where you went to school, your family, what your practice looks like.
My name's Ian Flora. I'm an attorney from South Bend, Indiana. I grew up in South Bend, Indiana. I went to Marion High School, IU undergrad, and IU Indy for law school. I've been practicing mostly in the St. Joseph County area for about 20 years. And most of that time, it's been either debtor or creditor law. Probably the first 5 years of my career, I was mostly a debtor's attorney. And for the last 15 years, I've been gone over to the dark side and practicing what's euphemistically known as creditors' rights. Pretty much what I do, my clients are out of town and out of state firms, banks, lenders, and debt buyers. And then I pretty much do the litigation portion for them across basically the northern third of Indiana, but at least once I've been to every county and every court in the state.
Wow. Mr. Septowski? I think you're muted.
I got mute again. I'm sorry about that. Yeah, my name is Ian Septoski. I'm with Kreisner and Associates here in South Bend. This year is my 20th year in practice, all in the area of creditors' rights, which I do probably 99% of my practices in that. Do a smattering of other things. I went to Purdue undergrad and Valpo Law School. My wife's also a lawyer. She's the chief deputy prosecutor for Berrien County, so she has a more interesting job according to our kids.
All right, very good. My name is Mark Telloyan. I grew up in southern Minnesota, moved to South Bend in 1994 when I got married. Attended Notre Dame Law School, graduated in 98, clerked for a local judge, Sandy Brook. And I had a teaching fellowship in Ireland at a law school there. Came back and was a deputy prosecutor for 4 years. Then I was thrust into the cold, cruel world of private practice. For the first 10 years, I did whatever came through the door: adoptions, business matters, driver's license cases, evictions, fire cases, guardianships. Then the last 10, I focused on bankruptcy. Also taught the bankruptcy class at Notre Dame Law School. In 2022, Governor Holcomb appointed me to the bench. So I just celebrated my 3rd year as a judge. Thank you to Amy O'Guire for setting this all up. And also thank you to the Ians for being the expert witnesses here. I have 6,000 contacts in my phone. There's only 2 Ians, and both of them are here today. So thank you.
Pleasure.
Last May, we did the first of what I would call a close reading. I have a master's degree in English, and I remember when I was in grad school, we sit around in a circle and we'd read a poem or short story or a chapter from a novel, and we just go sentence by sentence and kind of say what came into our head till we got to the end. I was wondering one day whether that approach would ever work for the law. And then I came across this tweet from Emily Bremer, who teaches at Notre Dame Law School. Really can't overstate how valuable it is to periodically reread the full, unedited versions of a foundational case. So that's the approach that we're going to take. Just go sentence by sentence, and I'll do the reading, and the Ians will provide the insights. I see a lot of actions where people renew judgments and seek to collect on judgment liens and claim that judgments have expired. And I just felt that I never really got my head around all the moving parts that involved execution on a judgment or proceeding supplemental. So one of the cases that somebody cited was Lewis v. Rex Metalcraft Inc. And I looked it up. 2005 case. Lewis is pro se, so some of his approaches are a little bit quirky. Comes out of Marion County. And the opinion is written by our own Terry Crone, who for a long time was the circuit court judge right here in St. Joseph County. Case summary. Thomas Lewis appeals the denial of his motion to invalidate execution judgment and rescind garnishment order. And we'll unpack all those terms in a second. Lewis raises two issues, which we restate as follows: whether the trial court appropriately granted garnishment for judgment that is over 20 years old, and whether Rex Metalcraft Inc. met applicable notice and leave requirements for the garnishment. Ian, anything jump out to you about these issues that we're going to talk about today?
Well, from my perspective, this is the entire ballgame here, and really goes to exactly what the court in this case and subsequent courts have consistently held, that there's no leave necessary to file a pro sup after 20 years.
Yeah, I agree. I mean, this case, and there's even a more recent one I read in the last couple of years. When you're meeting with pro se people kind of outside the purview of the court in the hallway, they're always kind of asking questions. And one they constantly ask is, what is the statute of limitations of judgments in Indiana? And unless they have a specific question where there might be something slightly different that applies to them, in general, there basically isn't one. As we'll get into with this case, there is the 10-year with the lien against the real estate, that if you want more than 10 years, you need to petition the court for that. But again, that's just one aspect of that a creditor may avail themselves for collection. A lot of creditors are never looking to do a foreclosure action or something like that out of their judgment. And then even the portions that speak about 20 years, it is a rebuttable presumption. So essentially, I have never seen a pro se defendant or even an attorney file one of these kind of an objection or anything to take action with the 20 years. Because again, it's a rebuttable presumption that they're saying that it was paid. So if you were to file this motion, part of your petition would have to be that it was paid. And if you haven't paid it, then what's it gonna, I don't even know why that exists.
All right, let's jump in. From what we can discern, the facts are as follows. First clue there is that things are a little bit murky. Rex Metal was granted a judgment against Lewis December 14th, 1982. On February 11th, 1992, the court renewed the judgment for an additional 10 years, which 10-year period shall commence. It's cut off on my screen here. To run on December 14th, 1992. June 8th, 2001, the court renewed Rex Metal's judgment for an additional 10-year period commencing December 14th, 2022. Ian, do you have any insight into this renewal process? Do a lot of people do it? I remember when I was in private practice, we get our judgments, and I can only think of once or twice that we actually renewed them. What's your take on that?
So I wouldn't say it's a common thing to do if your impetus is to collect the judgment through proceeding supplemental, because first off, a lot of the chances of having a judgment lien by virtue of your judgment are sort of speculative in the first place. I know that when I represent clients and get judgments for them, we usually don't know going into the judgment whether our judgment's going to create a lien on property or not. The way we find out is that at some point that judgment debtor might try to sell that property, and we get contacted by a title company asking us what our judgment payoff is. And so I don't think it's very common for my clients, at least, to want to renew their judgments. Again, they don't have to do that if they're only going to be trying to garnish wages or garnish bank account. The only reason you would ever need to renew the judgment is renew the lien itself on property, which I think we'll get into further. And that's sort of a different process. In fact, the process the court described in this case, in which Rex Metal renewed its judgment apparently within the same case, is a little bit maybe outside the norm, or not what you're supposed to do, quite frankly.
Was the logic of that for Rex Metal that their judgment amount was so great, $500,000, or what do you think they were thinking?
Yeah, it could have been.
Ian Flora, do you have a take on renewal of judgment liens? Or a renewal of judgments?
Yeah, I mean, doesn't it look like in this point that the plaintiff was represented by Rubin and Levin? They're kind of known for being one of the most precise creditors firms in the state.
Absolutely.
I think part of that is their due diligence. They were dotting I's, crossing T's. So there's no way to know from this opinion whether they were aware that there might be real property of value at some point. But one of the reasons, when you're talking about 20 years and the length of, personal mortgages or business mortgages that are sometimes a lot less than 30 years, is maybe when the judgment was taken within that first 10 years, there was real property, but no discernible equity. But then, when you're getting to 18, 19, 20 years later, and those mortgages are being paid by that business that's not paying your judgment, that could be building up equity that would be available to you. And you might want to look to foreclose on that property and pay your judgment or a portion of your judgment that way. So I think why they did it in this combination is the three things: large balance, top of the mark law firm representing plaintiff in the case, and finally, that you could be accruing equity in real property that didn't exist at the time of the judgment.
Interesting. Thank you. Lewis has failed to include a fact section in his brief, which was the only brief filed in this case. Although one of the pleadings alleges that the judgment was rendered against Lewis for the conversion of money from his employers, Lewis does not mention the basis for the judgment. On January 20th, 2004, in a motion for proceeding supplemental, Rex Metal asserted that it owns a judgment obtained in this court against Lewis on December 14th, 1982 for the sum of $511,000 and costs. The motion named Heritage Community Bank and Bank of America as garnishee defendants. In a motion to dismiss Rex Metal's proceeding supplemental action, Lewis argued that Indiana Code Section 3411-212 barred execution of the judgment. Question for the Ians: do you ever see debtors or defendants push back on the pro sup actions?
Oh, yeah. Yeah. I would say that just until recently, if you were to Google how long can a judgment creditor in Indiana collect their judgment, Google would have told you 20 years.
20 years, right? Yeah.
Would have told you that the statute of limitations is 20 years, and after that you're done. And I feel that question often, and my response was always that I need to look at this Rex Metalcraft case, because this indicates that that's not really true. The judgments effectively never expire in Indiana. I will say that recently I put that same question to Google AI or one of the AI services, and I got the correct answer to the question. Not sure it cited the correct law, but I got the correct answer. The judgments effectively do not expire.
In preparing for this CLE, I asked a half dozen lawyers about the statute of limitations on judgments, or how long judgments are good for, and all of them said, I think it's 20 years, but I'm not sure. So it is an area of some confusion. I think that's one big takeaway, though. Judgments effectively do not expire. On May 18th, 2004, the court issued a garnishment order recording the following property of Lewis in the hands of the garnishee defendant, FCN Bank, subject to execution, to wit, the lesser of 1.3 million, the unpaid amount of the judgment due from the garnishee defendant, FCN Bank, to Lewis as specified in the notice of garnishment proceedings, or the balance in the account on the date and at the time the garnishee defendant received the plaintiff's notice of garnishment proceedings summons in order to answer interrogatories, notice of hearing interrogatories, which shall be applied toward the satisfaction of said judgment. So help me out. What's going on here?
Well, so Mr. Flora's muted, it looks like, but what the creditor was trying to do here was issue what we call a bank pro sup to a garnishee bank to either garnish the amount in the bank account up to the judgment amount or a certain amount in the account to pay off the judgment.
I don't have anything smarter to add than that. I mean, it recites the amount of the judgment in case there's more than the judgment in the account. They only hold up to the amount of the judgment. That believe it or not, it is one of the screwier things I get at proceeding supplementals, because the number of times that I get pro se defendants come in and think their bank just paid off their judgment by reading that language in there or holding $70 or something like that and think the whole case is over. But so in this case, you got them suing somebody. They find out through an asset search or some kind of way they got the information about a couple places they have banks and send interrogatories. Their interrogatories to a bank are essentially taking a screenshot of what's in the account at the date that the bank receives the order to answer interrogatories, and the hold is basically on that date. I mean, there are some questions about whether money's added later or things like that, but basically it's just a look on that date and the hold happens from that date. In modern times, in that type of proceeding supplemental, defendants are sent notice that interrogatories have been sent to a bank with a form that allows them to request a sooner hearing than the proceeding supplemental, which is often anytime from 30 days to 90 days later, if they want to get into court quicker and explain exemption rights and things that shouldn't have been held in the case. But in this case, it looks like they were frozen, went through the full proceeding supplemental without an exemption hearing, and were ultimately levied on, which brought the action.
How did we get to a judgment of 1.3 million when it was originally 533,000? Is that just interest, or?
Yeah, I assume.
It is, and I didn't mean to interrupt the other Ian. But you are just about at, with Indiana's 8% per annum, when you look at a judgment and you're sitting down at a proceeding supplemental and you're right around 10 years later, it's basically doubled on you.
Okay, that's a good
So,
takeaway.
Yeah, a real shorthand on that. If somebody is like, why is it this amount or what's happening here? If I'm seeing you 10 years later, it's doubled, and that's why.
So judgment amounts double every 10 years due to the 8% rule.
Yep.
And there's case law that I can't remember the case now, but there's a good case that explains exactly how the interest should be calculated.
Is it just simple interest or something
It
else?
is simple interest, but what the Court of Appeals said was basically that you take the interest from that accumulated since the last time a payment was made, and each subsequent payment pays that interest off, and then whatever is left from that goes to pay the principal off. Now, I will tell you that none of my clients have us actually calculate interest that way. The way our clients primarily have us calculate interest is much more favorable to the judgment defendant in that, but that's what Indiana law does allow. And my reading also allows that that interest on costs is also proper.
And I would agree with Ian on that.
Lewis provides us with no explanation for the change in the garnishee defendant's name, and is further ordered, adjudged, and decreed that said garnishee defendant, FCN Bank, be and is hereby ordered and directed to pay to Reuben and Levine forthwith the lesser of the unpaid amount of the judgment or the balance in the account at the service time to be applied toward the satisfaction of said judgment. I've always been curious, how do collection firms or collection agents find these bank accounts? Is there some master database, or do you just scattershot? How do you come up with those bank names?
That's a good question.
Trade secret?
Well, no, it's not. Unfortunately, I don't know of any service that will give you bank information. I've heard of maybe some, but I don't know how accurate they are. I have heard of some judgment creditors who will just do a Google Maps search of banks nearest, banks that are nearest where the debtor lives, and
Yeah,
banks. Now,
the 5 closest ones, huh?
I don't know if that passes muster. I don't know if you have good faith to believe that or not, but I've seen it happen before.
Could you theoretically send your pros up to every bank in town?
That's what I wonder. Do you have a good faith basis to believe that the judgment debtor has accounts simply by virtue of the fact that it's in the same town or within a certain vicinity of where they live? I don't know the answer to that question. I will tell you that I think the smart thing to do is that if anytime a debtor is going to make you a payment, even before judgment, even in your transaction with your client, to keep track of whether they have a bank account. When people make payments to my office, we often track the bank information just for that purpose.
Uh, I think the answer to whether you can shoot every bank in town, I guess my answer is there was a long period of time when a lot of my clients were doing that. I would go to a proceeding supplemental and there would be, 10 bank interrogatories sent out. And that was back before Odyssey, and I'd have to thumb through a paper file trying to find if any came back with a hit. And also, a lot of counties, they're even the county seat, there might be one or two banks in town kind of thing. So I think you can do it. Do I think it's a good idea? Yeah, I don't know, but I think you can do it. The other thing is there are third-party vendors that do asset searches, so you can pay a fee and have a place kind of give you that information.
On May 27th, 2004, Lewis filed his supplement of points to a fact to defendant's motion to dismiss and sworn statement of residence, in which he stressed the renewal or extensions of the judgment period is not the issue. The only issue in my motion to dismiss is the execution of the judgment. Indiana Code 34.11.212 clearly mandates that a 20-year statute of limitations for execution of a money judgment. So this is the defendant's take on the law. Rex Metal responded that its preceding supplemental was filed on January 20th, 2004, well within the 20-year period beginning on December 14th, 2002. Further, Rex Metal maintained that the presumption that a judgment is satisfied after a period of 20 years is rebuttable. On June 1st, 2004, Lewis filed a motion to validate execution of judgment and to rescind garnishment order. Rex Metal responded. On June 28th, 2004, the court denied Lewis's motion to dismiss the pro sup. The court continued the pro sup indefinitely. On July 27, 2004, Lewis filed a notice of appeal. Panel of this court dismissed Lewis's appeal without prejudice, explaining a pro sup involves the right of the appellee to levy on the property of the judgment defendant, McClure Oil. This issue has yet to be decided by the trial court. The trial court's denial of appellant's motion to dismiss the preceding supplemental simply had the effect of allowing appellee's pro sup to move forward. The denial of the motion to dismiss did not dispose of any issues between the parties in the action. 4, as no final appeal order has been issued in this cause, this court is without jurisdiction to entertain this appeal. On December 7, 2004, Lewis filed a motion for a court order judgment on defendant's open and pending motion. 2 days later, the court issued an order denying Lewis's motion to invalidate the execution. All right, any insight into this give and take between the creditor and the debtor and the appellate court dismissing the first action?
No. Other than it's just the gears running.
The gears are slowly turning. Discussion and decision. At the outset, we note Indiana's law is well settled that a litigant who chooses to proceed pro se will be held to the same established rules of procedure as trained legal counsel. That's the Diaz case. We must hold Lewis to the same standards as an attorney. We further note that Rex Metal has elected not to submit an appellee's brief. When appellee does not submit a brief, an appellant may prevail by making a prima facie case of error, a less stringent standard. Town and Country Ford. Prima facie in this context is defined as at first sight, on first appearance, or on the face of it. The prima facie error rule protects this court and relieves it from the burden of controverting arguments advanced for reversal, a duty which remains the counsel for the appellee. What's Rubin and Levin thinking here, not filing a brief?
I don't know. It's a good question. I don't really know. It could just be that, the client didn't want to pay for it.
Yeah, that was my conclusion, or his claims are so wackadoodle that they figured they'd get shot down anyway. All right, let's come to the meat of this 20-year time period. Lewis contends that the trial court erred by granting Rex Metal's order of garnishment and by its denial of Lewis's motion to invalidate the execution of judgment, which is barred by the statute of limitations. Specifically, he notes that on January 20th, 2004, motion for pro sup, which he terms a motion for execution of a 1982 money judgment, should have been barred by the 20-year statute of limitation found in Indiana Code 3411-212. For support, he cites the case of Aaron v. Etzler. Ian Flora, can you explain the difference between an execution and a pro sup and what's going on here?
I think if I said no, that would probably be the issue of why this came up. Is I think it's I mean I think it's fun with language. I mean the three terms that apply are lien, levy, and execution. So lien would be taking control of or constructive control over an asset. Levy would be to execute on that so I guess I'm using all the terms, would be executing on that asset. So here we have a bank interrogatory. The proceeding supplemental starts by telling the court, hey, we have this judgment out there. The judgment date was whatever, 1982, 500 and some $1,000. Here we are at a period later where it's $1.25 million. Then it recites all proceeding supplementals that has to have the recitation that the plaintiff believes a levy of execution against the defendant will not satisfy the judgment, so they're looking for basically another venue. The levy of execution there refers to the idea of sending notice to the sheriff that they have assets that you can grab a hold of that have not been filed as exempt with the court, taken and sold at auction, turned into cash money, and paying off the judgment. In theory, under Indiana code, that is the first way that you are supposed to get paid on a judgment, when the defendant doesn't walk into the clerk's office and pay the judgment in full when you win your case. As we know, that seldom happens. Also, seldom do people have tangible assets to go and be nabbed up and turned into cash to pay off money judgment. Also, as somebody who has tried doing this in the past, filing the notice and sending the execution order to the sheriff, executing meaning going and taking the stuff, sheriffs tend to refuse to or find any excuse not to do it. So
we lost your paperwork.
To explain the term. Yeah, so here in the bank hold, you're telling the court you think the bank may have asset money on hand that belongs to the judgment defendant, and you're asking them to put a lien on it. So that a lien here is a hold. It's like frozen assets in a bank account that the debtor no longer has access and use and enjoyment of, often put into a separate suspense account or something like that by the bank, and the banks are allowed to charge a statutory fee for doing this. At that point, there's just a lien on those assets. Nothing has happened with them until there's a final order of garnishment. The final order of garnishment is plaintiff levying on those assets. And then when the garnishment order is received by the bank and it sends the money in certified funds to the clerk of the county in which the judgment is in and the order has been issued from, that is the execution. So, I mean, this is a Court of Appeals case. Pro se defendant is putting together paperwork and filings to get it into legal terms, but essentially all he cares about in the case, and this is one of the reasons people do bank holds, it definitely gets defendants' attentions that have been, I know, ignoring paying their judgments or working on the issues. It gets back to he's trying to stop them from taking money that obviously they have on hold in these accounts. So
let's say I have a $1 million judgment against Fred Smith and I see him driving around town in a red Corvette. How do I execute on that judgment?
Yeah, it's a good question. I think the way to execute on it, as Mr. Flora said, is to get an order for the sheriff to go out and seize it. I don't know how effective that's ever going to be.
Yeah, Judge, that's correct. As we were talking about a little bit offline before we started this today, the case in which I had did a levy of execution was, set a proceeding supplemental, might have been a bank proceeding supplemental just like this, met with the defendant informally in a courthouse in Delaware County, Indiana, examined him as to assets and income. I don't think there was any bank holds or any issues or any real money in a bank account to execute on our judgment, but he disclosed that he was self-employed and had a retail storefront computer repair business. Well, the ownership of things in there at time, I mean, there's he's taking other people's computers, Bailey's, things like that. But essentially, you got somebody that's self-employed, and you're not going to get a garnishment order fulfilled in that case for wages or something like that. So about the only way to execute on that was, you know, he's got X amount of computers in the store, and file notice with the court that for a sheriff's deputy to go there and take possession of all computers and computer related paraphernalia in the store, as well as his cash register.
And his cat.
Yeah, and again, this is just a notice you file with the court. It's not even a motion. You're not even seeking an order. There's no judge line on the notice. It's you just put it there to satisfy some statutory requirement, and then you serve it to the sheriff's office. In my case, at the time, I walked across the street to the sheriff's department in Delaware County and handed it to them. Then the real battle started with just months of them. Nobody knows how to do this. Nobody knows, is this even right? Because it's not signed by a judge. You guys need to hire, rent a storage space for us to put the stuff in. And even that's not true. Like in the budget of the sheriff's offices, if you're having them execute on property, it is their responsibility to store it and make it available to you. So anyways, in that case, it eventually sorted where the guy came around to a nice little payment plan rather than have that actually happen. But I do like to point that out, and I, like I said to you earlier, is that there's a distaste for the forceful nature of proceeding supplemental. It is forcing somebody to do something in a civil setting to get payment on a judgment. And then I like to remind people that, in theory, the statutes presuppose that we start off by taking all of their personal property that they haven't filed an exemption form with the court about. So I don't know, maybe a wage garnishment isn't as ruthless as people like to make it out to be, as opposed to taking their dining room set and their couch.
In the movie about Charles Dickens, there's a scene where Dickens is a small boy and the debt collectors come into this house on Christmas Eve and are ransacking the house and taking the candlesticks and stuffing all their personal property into burlap bags and walking out.
Yeah, I can tell you the one time that this has ever been effective that I can remember is doing something that's colloquially called a till tap, where, like Mr. Flora said, the sheriff goes out and taps the till of the business. They open up the cash. I don't think it's done that often anymore. And I think the sheriff would be a little bit confused, as quite frankly I would be. If I wouldn't know what to tell the sheriff to do with the stuff if he got it. So
A till tap. I
yeah.
like it. We first observed that there seems to be some confusion regarding execution and the equitable remedy of pro supps. Pro supps to execution are enforced by verified motion, alleging the plaintiff owes the described judgment against the defendant, and the plaintiff has no cause to believe the levy of execution against the defendant will satisfy the judgment. Trial Rule 69E and the Indiana Code. So here's what Trial Rule 69E looks like. It's a little bit lengthier than most. The only issue presented in proceeding supplemental is that of affording the judgment creditor relief to which she is entitled under the terms of the judgment. Pro subs,
I'm
go
sorry.
ahead.
I think the preceding page really gets into the nuts and bolts about what the Rex Metalcraft court was saying. And I think that they're trying to carve out a difference between an execution on a judgment and a pro sup. That I think the logic there is that a pro sup is not an execution because under Trial Rule 69, in order to get an order for a pro sup, you have to tell the court that we don't believe an execution would recover any money for us. Therefore, it must be different. I don't know that that's really I don't know that that's really a distinction that has a difference in law. In fact, I think in earlier cases, specifically one Williams versus Leidick, which I believe is referenced in the Rex Metalcraft decision, I think that a pro sup was considered to be the same thing as execution in nature. And really, the only difference is that the property may be in the hands of a third party.
I know I've always conflated those two in my mind, but after reading this decision, I see how they're different.
Right.
Pro subs are a continuation of the underlying claim on the merits, not an independent action. As such, pro subs are initiated under the same cause number in the same court that entered judgment against the defendant. Kirk v. Monroe County Tire. In the concurring opinion that goes with this case, the author states that he believes that there should be, strike that. The validity of the underlying judgment has already been determined. Thus, proceeding supplemental may progress without a showing that execution has commenced or would be unavailing. The proceedings are a nullity absent a valid judgment. Thus, a reversal of the underlying judgment nullifies the pro sup. Even though proceeding supplementals are an extension of the underlying action, the parties cannot, during their course, collaterally attack the underlying judgment. At a pro sup, it's the duty of the judgment debtor to pay the judgment or to come forward with the property so that execution may proceed. What about the idea of collateral attack? Do you see that?
Well, yeah, that happens from time to time. You'll get a judgment debtor who attacks the validity of the judgment at the pro sup hearing. Most courts will tell that debtor that this isn't the appropriate place and time to do that, and not what we're here for today.
When I did bankruptcy work, people would bring in their stack of bills and there are 3 or 4 judgments, and those had some reason why the judgment was not valid. It wasn't me, or I didn't run up this debt or something.
I guess I would say the collateral attacks on the judgment, that issue is entirely based on how the court, the proceeding supplemental is taking place in, conducts their proceeding supplemental. If it is, on balance, the highest majority of counties in Indiana do this properly, where they're done outside of the courtroom, because again, the defendant doesn't have a motion in front of the court, that the defendant, it's not their hearing, they're ordered to appear and answer as to assets and income, so they're conducted in a hallway, and a report of whether or not the defendant appeared is filed with the court. a number of courts in Indiana do these with a judicial officer available or a judicial officer interjecting themselves into the process. And then they invent discretion that does not exist. And once a judge finds, or a pro se defendant who doesn't have the money or doesn't think they should have to pay, finds themselves in front of a judicial officer, they will say anything and everything. And the next thing you hear is the judicial officer explaining to them things that they could possibly do, like motions to set aside the judgment, etc. And instead of that being treated as judicial misconduct and ridiculous overstepping, which it almost always is, Marion County is open an entire office in their courthouse for the judges and prosups to send people to after their prosups to get, some employees help in filling out a trial rule 60B motion to set aside their judgment in their case. And everybody in Indianapolis thinks that's just fine. I mean, I suppose this case today would say it wasn't. And the Court of Appeals would probably say it wasn't. And yet here we are.
At the procept, the duty of the judgment debtor to pay the judgment or come forward with the property so the execution may proceed. Do you ever do a prosop and have the debtor just pay?
Yes. Yeah, that's happened. I always tell them to take if they bring cash, but they do kind of often. They think I'm just going to take $1,000 from them in small claims court. I tell them they have to pay to the clerk of court across the hallway if they do that. But yeah, it happens from time to time.
Interesting.
One time, several years ago, before I had that practice, a judgment debtor came in with cash, and I took the cash and I put it in my glove compartment. It fell back behind the glove compartment in my car, and I had to take the glove compartment out of my car. I had forgotten the person had given it to me. Fortunately, I was able to find it behind the glove compartment of my car. But yeah, so I don't do that anymore.
Generally, 3 types of relief are available to a judgment creditor through a pro sup. The judgment debtor is required to appear before the trial court and be examined as to available property. Judgment debtor is required to apply particular property to the satisfaction of the judgment. Third-party garnishee is joined as a party and is required to answer as to non-exempt property held by the garnishee for the debtor or an obligation owing from the third party to the debtor. Anything on these 3 types of relief?
Well, the third one I think is the most interesting one because that really gets into how broad the power is in a prosup to not only find assets from that party that are executable later, but also you can get information from the garnishee defendant to give you more information about where else you can execute. So, for example, in our interrogatories that we serve on garnishees in a prosup, we ask the employer if you know where the debtor lives and also where they have a bank account. And if you're the employer and you're doing direct deposits and you give me the information where the debtor has a bank account, that leads me to further assets potentially.
So the only third-party garnishees that I see are banks, credit unions, or employers. Can it go broader than that?
Yeah, certainly. I'm thinking about a case in which we have a large judgment against a business, and through the prosup process, I was able to get a list of all of their clients. Any client that's paying them ostensibly, I can issue a prosup to any of those clients for money that they're holding or they owe to that business and be able to garnish that money or execute against that money.
Wow.
Also, I think anyone who owes a debt to my judgment defendant. Specifically, I think it's in the garnishment statute specifically that it says basically that if the judgment debtor is owed a debt by a third party, my client can ask the court to have that debtor's rights to that debt be assigned to my client.
Property subject to supps includes both real and personal property. Has been stated, Indiana Code 3411-212, entitled Satisfaction of Judgment as after expiration of 20 years, is applicable to money judgments. Every judgment and decree of the Court of Record, United States of Indiana or any other state shall be considered satisfied after the expiration of 20 years. Despite being listed in a chapter titled Specific Statutes of Limitation, this section seems unlike a standard statute of limitation. Indeed, 3411-212 does not contain the same language as other sections within the same chapter. Employment actions brought within 2 years, professional services related actions brought unless within 2 years, injury or forfeiture or penalty actions commence within 2 years, real property recovery actions commence within 5 years, actions against public officers within 5 years, actions on accounts or contracts not in writing must be commenced within 6 years. Real property execution actions must be commenced within 6 or 10 years. Actions on promissory notes, bills of exchange, 6 or 10 years. Actions to enforce child support, not later than 10 years after the 18th birthday. Action on written contracts other than those of payment of money must be commenced within 10 or 20 years. Anything jump out to you about those statute of limitations?
No.
Long ago, it was explained that Indiana Code Section 3411-212 is not in any sense a limitation on the life of a judgment. It's merely a legislative declaration of a rule of evidence. All right, so back to our first takeaway, judgments effectively do not expire. A judgment less than 20 years of age is in itself prima facie proof of a valid and subsisting claim, but under this rule, a judgment more than 20 years of age stands discredited, the lapse of that period of time being prima facie proof of payment. But in either case, the presumption is rebuttable. Stated more strongly, we find nothing in our statutes indicating an intention to utterly destroy judgments, even after the lapse of 20 years. The Dell appearance on rehearing went so far to state as we are not aware that the legislature has the power to decide or declare arbitrarily that a judgment has been paid when in truth it has not been paid. Odell Court clarified that the statement within Brown to the effect that a judgment cannot be enforced after 20 years is not a judicial decision on the point and is not binding on the court. To avail oneself of the presumption of satisfaction of a judgment upon the passage of 20 years, a party must plead payment. So once again, judgments are not barred after 20 years and continue on, and that's just a presumption that payment has been made. That presumption can be rebutted. Although in the proceeding below, Lewis raised Indiana Code Section 3411-212, at no time did he plead payment. Moreover, in its verified motion on pro sup, Rex Metal stated that it owned a judgment against Lewis for $511,000, the 82 amount, that had no cause to believe that execution would satisfy the judgment. Rex Metal further stated that it believed that Lewis has wages, assets, income, profits, which could be applied. Rex Metal's assertion of non-payment, coupled with Lewis's failure to plead payment, overcomes the presumption. All right, before we leave this section, anything on it?
Well, what jumps out to me about that is the rebuttable presumption aspect of it. The court is here saying that after 20 years, the plaintiff, there's a rebuttable presumption that the debt's been paid. The onus is on the judgment debtor to file, I think it's a trial rule 58 motion, saying this judgment has been paid and should be released, which then puts the onus on the judgment creditor to file an affidavit of response indicating that's not paid. Outside that process, the court is saying that all a judgment creditor must do to continue the pro sup process is file an affidavit saying this judgment's not paid. And since trial rule 69 requires that a proceeding supplemental be verified, essentially just by filing a trial rule 69 pro sup, you are
That's what you're doing.
you're telling the court that the judgment's not paid and you should be able to conduct a pro sup on that judgment.
Next section deals with leave and of the court and notification. Lewis next argues Rex Metal did not request and was not granted leave of the court to obtain an execution of the judgment, nor did they give notice to Lewis of this execution of the judgment. He contends the garnishment order was filed after he left court 2004, that he did not receive notice of the order until his bank sent him a letter. Again, we look to the rule entitled pro supps to execution. Notwithstanding any other statute to the contrary, proceeding supplemental to execution may be enforced by a verified motion or with affidavits in the court where the judgment is rendered, alleging generally plaintiff owns the judgment, no cause to believe a levy of execution will satisfy the judgment, defendant be ordered to appear, person is named as the garnishee will have specified or unspecified non-exempt property. The court determines that the motion meets the foregoing requirements. It shall ex parte and without notice order the judgment debtor, other named parties, defendant, and the garnishee to appear for the hearing thereon or to answer the interrogatories attached to the motion. So I have electronic key that I work through every day, and a lot of what I'm doing is just signing orders to appear on pro supps. 2024, over 6,000 collection cases were filed in Superior Court. Most of those become judgments, so there are many, many, many pro supps going on. The motion along with the court's order stating the time for the appearance and the hearing for the time to answer interrogatories submitted with the motion shall be submitted upon the judgment debtor filed in Rule 5. Garnishee is entitled to service of process provided in Rule 4. The date fixed for appearance and hearing or to answer the interrogatory shall not be less than 20 days after service. No further pleading shall be required. Case shall be heard and determined. Property ordered applied towards the judgment in accordance with statutes allowing proceeding supplementary to execution. In aid of the judgment or execution, the judgment creditor or successor in interest of record, the judgment debtor may utilize the discovery provisions of these rules in the manner provided in the rules of discovery 69E. Trial court is vested with broad discretion conducting pro supps. Pro supps as provided in trial rule 69 are summary in nature because the claim has already been determined to be a justly owed debt. Likewise, the judgment debtor in a pro supp is not afforded all the due process ordinarily afforded to civil defendants. All right, anything on those sentences?
Mr. Flora is still muted, but I can kind of weigh in. I think it's just another recitation of what the nature of a pro sup process is.
Yeah, I mean, the only thing that stood out for me in there was, the astronomical amount of these kind of cases that exist, the 6,000 something you see, and which is why, as we've covered previously a Court of Appeals case about summary judgment, and we covered this one today about collections, that the vast majority of cases that get to the Court of Appeals, I think they recognize with the huge volume that essentially these cases just need to work and they need to be enforceable contracts, and folks need to have a venue for getting collection on them. And that kind of fiddling around the margins and trying to find little ways that there's a hiccup in a pleading or a hiccup in a form or something like that is, if at some point a misspelled word in an affidavit of debt puts all forms of violation of Rule 9.2 or something like that, then you have 6,000 cases just in your court alone that suddenly got, thrown on their face and heading towards litigation. And I don't think courts can sustain that amount of actual courtroom time.
we would collapse under the weight. All right, I show it's 12:57, got about 3 minutes. From what we can tell, the court determined Rex Metal's motion met the requirements of 69E. 69E was followed. The case was heard and determined. Lewis has not demonstrated otherwise. Garnishment is not a new adjudication. To the extent that Lewis relied on 3555.1.2, we note that Rex Metal need not have met the requirements of this section as they're inapplicable to a pro sup. Then there's a section on issuance after lapse of 10 years. After the lapse of 10 years, after an entry of a judgment issuing of execution, execution can be issued only by leave of the court or upon motion. When the execution is issued on leave of the court after subsection A, service of notice may be made by publication. Leave shall not be given unless it is established by oath or other proof that a judgment or part of the judgment remains unsatisfied. What is this about lapse of 10 years and such?
So a couple of things I want to note about that, and it might be important for anyone who's on the call today to maybe look at a few cases that have come down from the Court of Appeals just in the last couple of years. One of those cases is H&S Financial versus Parnell, which is a 2023 case out of Marion County. In fact, it started in a Marion County small claims court that's known as being very debtor friendly. And the Court of Appeals really in that case, it's 214 Northeast 3D 1030. The Court of Appeals really reaffirmed this Rex Metalcraft case and laid out a specific framework regarding the pro sup process and how that differentiates from executions. Furthermore, there's another case that came out in 2024, Converging Capital versus Steglich. That case also provides a very good recitation and reframing, I think, of the Rex Metalcraft. An important case was Auto Vest versus Abner, which is a 2024 case, which is 245 Northeast 2nd 3D 193. And that case really explains the difference between, that case is really on renewal judgments. A creditor might renew its judgments every 10 years because renewing your judgment gives you another 10-year lien on property. You don't have to do it, but it gives you another lien on property. And what this court is saying is that the proper mechanism to do that is actually to file a new case in a new cause number to renew your judgment. You get a new 10-year judgment. Even if you don't have a lien by that process, with leave of court, you can still execute on property just without the benefit of having that judgment lien. And finally, there was a case that came down in 2024, Chitwood versus Guadagnoli, I think I'm pronouncing that correctly, which is 230 Northeast 3D North 932. And that case really kind of explains the interplay between the judgment lien process and bankruptcy. And effectively what the court said in that case is that you get a stay, your lien, you get an extra time on your judicial lien if your case was stayed in a bankruptcy, it was dismissed.
Very good. Thank you. I show that it's 1:01, so we are out of time. Just going to go ahead and flip through the rest of these slides here. The case cites old case law, Yeager, 1887. And that is the end. Accordingly, the pro sup as a continuation of the original action would be permitted at least through December 14th, the Hines case. Therefore, the state court's ruling was affirmed. Darden concurs, Matthias confirms, and then Matthias wrote a concurring opinion, which we don't have time to get into today. All right, that's all that we have time for. Thank you very much for attending. Amy, I'll turn it over to you.
Thank you so much, Judge, and thank you to both Ians. We appreciate it. I did ask in the chat. It didn't look like anyone had any questions, but I'll give you a quick 1 minute if anybody has anything. Oh, we got to thank you. Okay. Well, we appreciate your thoroughness and thanks for doing this.
All
you.
right.
Take care.
This CLE is adjourned.
CLE is adjourned.